With so much information that has been released regarding the SEC versus Ripple lawsuit, this news is shocking. XRP is not to be used in retail stores. Want to know more about it? Stay tuned so you won't miss a thing. Welcome to Crypto Live. Don't forget to like this video and subscribe to our channel to stay updated on our upcoming videos about cryptocurrencies. It seems that Ripple is on its way to victory against the lawsuit. Is Ripple's SEC case just another great step forward for cryptocurrency? How did it all unfold? Does that mean Ripple has won the fight against the SEC for good? Make sure to watch to the end to find out. Is Ripple actually having a pretty bad time? John Deaton's motion to extend the expert discovery deadline has been denied by Judge Sarah Netburn, who ordered that the SEC extend the deadline to January 14, 2022. Also, in a statement by Judge Netburn, which was tweeted by @CryptoLawUS, while the court recognizes that both parties have dedicated substantial resources to prosecute this case, given the pending motions to dismiss and strike and the previous adjournment of any deadline to file a motion for summary judgment, the additional time sought by the SEC will not affect the schedule to resolve this case. Rather, the additional time sought by the SEC will allow both sides to complete the outstanding fact discovery and properly prepare for expert depositions. Things turned out differently, however. In particular, the SEC should explain how to apply the Howey test to XRP. Further, how Ether and Bitcoin are currently doing, as well as XRP's availability for purchase as an investment contract. Astonished by the move, U.S. District Judge Sarah Netburn granted an extension to the expert discovery deadline for the SEC versus Ripple litigation in the same week that she decided to hear two outstanding motions. Also, the SEC is required to provide clearer answers to interrogatories after it has responded to individual defendants' motion to compel. Additionally, the order demands that the SEC follow the protective order, which relieves it from the responsibility of responding to 29,947 individual requests for admission. In light of the fact that certain aspects of the discovery sought overlap, both applications are processed together. In the end, Judge Netburn concluded that he had granted partial permissions to both motions while denying them in part. In addition, the judge ordered the SEC to respond to around 30,000 requests for admission, including requests about whether a document is legit or authentic, requests about the fair notice argument, and requests about Ripple's extraterritorial defense, among other things. Further, the defendants protests that the number of requests is reasonable and that narrowing the topic of prosecution is theater were dismissed. While the defendants claim that this volume of requests is reasonable and will narrow the issues for trial, it is almost impossible to see this stunt as anything other than a theatrical stunt. And according to the SEC's legal theory, it is not entitled to a response to the defendant's factual query. Moreover, Judge Netburn, in answer to Ripple's interrogatories regarding SEC's position on cryptocurrency investment contracts, stated as such. Additionally, they cannot be used to answer questions that are unrelated to the original question. The statement must also be provided by the Securities and Exchange Commission, SEC, regarding whether Bitcoin and/or Ether are securities as defined by Section 2 of the Securities Exchange Act of 1933. This despite the agency's previous assertion that it is not responsible for determining whether financial instruments constitute securities under the 1933 Securities and Exchange Act. What are your thoughts on Ripple's chances for winning this case? My personal opinion is that Ripple has a high chance of succeeding. What do you think? Let us know what you think down below. When there are disagreements between the parties regarding the application of Howey and its descendants, the parties' disagreement over the application of Howey and its progeny does not render Ripple's interrogatory inappropriate. And the Securities and Exchange Commission, SEC, is also required to respond. On the other hand, Judge Netburn denied Chris Larson's motion for a summary judgment on the issue regarding whether the XRP ledger was not fully functional prior to the start of the continuing securities offering, as well as when it became functional, which was determined by the SEC's interpretation. And when did it become functional? As a consequence of the court determining that the interrogatory was vague, the parties were ordered to reach a settlement and negotiate in good faith to clarify its terms. This is because a general lack of transparency persists in the digital asset industry, and nearly everyone is in agreement with this statement. It is unlikely that the SEC versus Ripple lawsuit will benefit the sector directly, but it may contribute to future enforcement actions and lawsuits brought by other companies against the SEC. In addition, Ripple's CEO, Garlinghouse, has been expressing his opinion on cryptocurrency regulations and the state of the cryptocurrencies market, and it appears as if he's got a grudge against the Financial Industry Regulatory Authority, FINRA. Furthermore, in his remarks at the DC FinTech Week virtual conference last October 22nd, Ripple's CEO asserted Ethereum now has official clearance allowing it to surpass XRP as the largest cryptocurrency by market capitalization. As we all know that U.S. securities commissions are pursuing Ripple over allegations that its cryptocurrency disputes XRP as an unregistered security, also the SEC was asked by Ripple in January to explain why Ethereum was not considered to be a security under the Freedom of Information Act. Meanwhile, in July, almost 6 months after the business filed its initial request, the New York District Court granted the request to depose a former SEC officer who had previously said Ethereum was not a security. Clearly, Garlinghouse believes his company has been unfairly treated, and that at the very least, Ethereum's subsequent success can be partially attributed to the SEC's more permissive cryptocurrency regulation. Furthermore, he added that it has an impact on the market because, within the last few years, XRP was the second most valuable digital asset, and it became clear the SEC had given a hall pass to ETH. ETH obviously has kind of exploded, and that clearly has helped. For instance, the Securities and Exchange Commission's harsh position toward cryptocurrency can be seen through the recent proceedings against Garlinghouse's own company and Coinbase. As a result of Ripple's legal challenges with the Securities and Exchange Commission, he reported that the SEC is claiming to protect customers, yet actually doing the opposite. In his response to the SEC, quote, "You have nearly 50,000 U.S. people who hold XRP who are trying to sue the SEC for protecting them," close quote. In fact, lawmakers also criticized the SEC's dismissive attitude toward cryptocurrencies, including XRP. Tom Emmer, a Minnesota lawmaker and co-chair of a group of legislators interested in blockchain technology, wrote to the editor stating that Gensler may have exceeded his authority in wanting to regulate cryptocurrencies such as XRP through the SEC. Then, in response to proposed reforms by Democrats to improve oversight of the $2 trillion cryptocurrency business, Bitcoin enthusiasts are mobilizing a larger movement to fight those actions. And one aspect of this movement is Emmer's intervention. Comment #CryptoLive if you believe Emmer is right. On October 19th, Gensler informed Congress that cryptocurrency platforms should be registered with the SEC, and further added that, quote, "Right now, investors don't have the benefit of that basic bargain that we protect people against fraud and manipulation. People are going to get hurt," close quote. In response, Emmer said, quote, "I disagree with Gensler strenuously when he suggests that almost all of these crypto products are securities. I think the vast majority of cryptocurrency offerings or related offerings are actually currencies or commodities. The SEC is not involved," close quotes. Also, he is opposed to the SEC's general anti-crypto policies, and especially dislikes that they have damaged Ripple and XRP so significantly. So, what are your thoughts on the latest news about Ripple and SEC? Are you optimistic that they will result in Ripple winning this case? Share your thoughts below. Also, don't forget to like this video. Moreover, simply because Ripple is using its DLT to get banks and other institutions to use it does not mean XRP isn't for retail users. It is the main feature of a distributed ledger that it can be accessed by anyone with an account. And any possibility is possible, but I do not think that barring retail from using XRP is a likely scenario. Meanwhile, this shocking news has a high likelihood of sending XRP to $100. With this, remember that cryptocurrencies' prices change frequently, so by the time you watch this video, their value may be entirely different. That's all for this video about crypto, and thank you for watching. If you would like to receive updates on the crypto market, make sure you click the subscribe and bell button.